Why is the SEC trying so hard to destroy the cryptocurrency? Why is XRP chosen for these purposes? Will the SEC be able to start regulating cryptocurrency? We will try to answer these questions in today's video. A pro-XRP legal expert has weighed in on the SEC's litigation against Ripple, which seems to be nearing its end. On a March 10 Twitter thread, former lawyer and Evernote XRP co-founder Scott Chamberlain identified 5 possible outcomes for the lawsuit, including summary judgments, settlement, and further proceeding. The legal expert said the regulator didn't have anything near the evidence to suggest they intentionally or recklessly offered an unregistered security for Ripple CEO Brad Garlinghouse and co-founder Chris Larson's summary judgment. Chamberlain claimed that Ripple's sales of XRP on international exchanges are not within the court's jurisdiction and that an entirely new precedent would be created to declare those domestic transactions concluded in the U.S. for the summary judgment for Ripple. Chamberlain said that this lawsuit might investigate whether Ripple sold XRP tokens in the U.S. with unregistered investment contracts. The Evernote XRP founder's 5th possibility is that the dispute resolves if the court establishes precedence on XRP's security status and international sales jurisdiction. According to his reasoning, however, Judge Annalisa Torres ruled on both sides' applications to exclude several expert witnesses, including one that Chamberlain and Ripple's amicus curiae John E. Deaton thought detrimental for the SEC's position. New York Attorney General Letitia James sued KuCoin for acting as a securities and commodities broker, dealer without registering in the state, Feinbold reported. Former lawyer and Evernote co-founder Scott Chamberlain has 5 predictions concerning the SEC's lawsuit against Ripple. The Evernote co-founder thinks the SEC will lose its action against Ripple executives Brad Garlinghouse and Chris Larson. The SEC accused Ripple executives of assisting and abetting the selling of unregistered securities. Excerpt. According to crypto law founder attorney John E. Deaton, the SEC must establish that executives were reckless in not knowing XRP was a security. Chamberlain claims the SEC lacks proof. The former attorney said recognizing these as U.S. transactions would create a precedent. Third, the XRP Layer 2 architect predicts that the court will reject the SEC's allegation that XRP is a security. This suit attracted Deaton, who represents thousands of XRP holders, as a friend of the court. Chamberlain, like Deaton, claims the SEC lacks precedence. The former lawyer claims the regulator did this to avoid analyzing each XRP trade and addressing foreign sales. The former lawyer's last forecast is that Ripple's U.S. XRP sales included an unregistered investment contract. Chamberlain believes his 2nd and 3rd forecasts will lead the SEC to settle. The former lawyer said the SEC underestimated Ripple's XRP sales abroad. The prolonged legal struggle is nearing its finish, at least at the district level, so curiosity over its fate is high. Deaton's forecasts and assessments mostly matched Chamberlain's. The attorney projected no out-of-court settlement until a summary judgment, finding to delay a trial or appeal. The crypto law creator also believes the SEC can only win if Ripple marketed securities from 2013 to 2017. According to Deaton, he does not anticipate that Judge Torres will experience a major delay in rendering her decision about the summary judgment motions. Attorney John E. Deaton is of the opinion that a decision will soon be made on the complaint brought against Ripple by the United States Securities and Exchange Commission. This information was made public in a tweet by the founder of Crypto Law today, in response to inquiries about whether the release of the judge's decision on Dalbert motions gives any hints on the timeline for her summary judgment decision. In his capacity as a friend of the case, the Crypto Law founder represents thousands of XRP holders. Deaton stated his uncertainty on the likelihood of severe holdups. The attorney said that the judge may hand down her decision as soon as tonight, or it might not come until a few weeks from now. According to what has been published today, the judge's order on the Dalbert motion indicates that she partially allowed and partially declined requests from both parties to strike out expert evidence. As the report highlights, XRP holders were the biggest winners as a result of Judge Torres striking out expert opinions that the SEC used to support its claims that XRP holders purchased the token with reasonable expectations of profits solely from Ripple's efforts. XRP holders were the biggest winners as a result of Judge Torres striking out expert opinions that the SEC used to support its claims that XRP holders purchased the token. It is important to keep in mind that the counsel for the defendant in the case said that the decision about whether or not XRP is a security might take a further 2 months. According to what Ripple's general counsel Stuart Alderity said not so long ago, there are 3 possible possibilities. It is possible that the court will rule in favor of Ripple or the SEC, or it may decide to go to trial. Deaton has said that the clarification of the SEC's contention that sales of XRP on secondary markets represent unregistered securities offerings is the conclusion that he would most like to see the court reach. Even if Ripple is ultimately unsuccessful in the lower court, owners of XRP would still be able to claim a huge win if the judge rules against the SEC's position on this issue. According to X, attorney and Evernode XRP co-founder Scott Chamberlain, neither the SEC nor the XRP community seem to have benefited by the current verdict. Chamberlain's remarks followed a recent decision by Judge Annalisa Torres, who granted and denied portions of both sides' applications in equal proportion. Expert testimony is essential for Ripple and the SEC to back up their statements and proof about XRP. As the court approved and rejected sections of both sides' motions, neither the SEC nor the XRP community seems to have benefited from this decision. One of the most important effects of the decision was the exclusion of Patrick Doody, the key expert witness. The SEC had hired this business to look into investors' expectations for XRP. Another unintended result of the Dalbert issues was that SEC lawyers tried to have Judge Torres exclude John E. Deaton, an XRP community attorney, from participating in the litigation, in part because Deaton had revealed the identity of the SEC's expert witness. The judge, however, did not prohibit Deaton, but instead agreed with him that Doody should not testify in court on behalf of XRP holders. Similar views were expressed by XRP community attorney Jeremy Hogan, who said that the SEC must show that investors had a reasonable expectation of benefit from Ripple's efforts, and that Doody was critical in demonstrating this. While the judge ruled in favor of the SEC on expert witness number 3, which Ripple had deemed irrelevant and unreasonably prejudicial, Hogan believes that expert E3's opinion as to Ripple's incentives and actions to influence the XRP price is relevant to the issue of reasonable expectation of profits, yet he considers it weak sauce, meaning that it will be ineffective in this circumstance. According to attorney John E. Deaton, the U.S. Securities and Exchange Commission made a serious error in identifying Ripple executives Brad Garlinghouse and Chris Larson in their enforcement case against Ripple Labs. In a long Twitter thread yesterday, the CryptoLaw founder sought to explain why Judge Annalisa Torres disregarded the SEC's objections to Ripple expert testimony on the non-security status of XRP by other authorities. He said that these testimony addressed whether Ripple officials were imprudent in failing to recognize that XRP was a security. The SEC will need to show this, as previously stated by the attorney, for the court to find the executives guilty of aiding and abetting the sale of an unregistered securities. The attorney said multiple times that several other government bodies, including the SEC, had considered XRP as a non-security, and that the agency had saddled itself with an unneeded burden. Deaton speculates that the regulator used this action to compel a settlement or to weaken Ripple's support in the young market. Yet, in his opinion, this was a significant blunder, and the regulator will almost certainly lose on this point. The attorney representing 75,000 XRP holders in the dispute, as a friend of the court, has projected that the final decision in the legal struggle is imminent.